if you can't, let me know, please.
Yeah, I'm not seeing it.
Oh, really? Do you think it's Letitia? Do you think Lakeisha? Do you think it's because I put it in before the meeting started?
Could be.
Yeah,
So
I think
I
that's what
don't
it
see
is.
it. Yeah, I don't see it in
Okay, let me
there.
copy it and do it again.
Okay, well, while you do that, I'm gonna go ahead and get started. It's 9:01. Grand rising, everyone. Woo woo! Today is Wednesday. Welcome to Grand Rising Elizabeth Wealth Building Wednesday. Wealth Building Wednesday. Shout! How are you doing today? Uh-oh. I
I'm
hope
doing great. I am doing fantastic, and thank you for inviting me, Lakeisha.
absolutely. Thank you for coming again. I'm very, very excited. I thank all the guests, everyone who came in today. I think this is just such a very great topic, to have. And so, people who know, I love to start the show off with a millionaire and billionaire success story, right? So, let's get started. Oh, there we go. Here. I'm excited about 2026. I'm still excited. We just have still got a long way to go, but I'm excited about all the things that is going on. I hope you all are excited about 2026 as well. Okay, so let me tell you about three families, okay? All extremely wealthy, all powerful, all started with one visionary. But their outcomes is completely different. Let's start with the Rockefeller family. Started by John D. Rockefeller in the late 1800s. Over 100 years later, over 6 generations later, the family is still wealthy, still influential. Why? Because they didn't just pass down money. They built systems. They built trust. They built family governance. They structured planning. They taught their family how to manage wealth and not to just spend it. Now let's talk about the Vanderbilt family, one of the richest families in American history. But within about 50 years, their wealth was gone. As at a family reunion years later, not one single millionaire remained. Why? Because there was no structure, there was no system, there was no plan. So now, the third family, the Ford family. Henry Ford built one of the most iconic companies in history. Over 100 years later, this just be blowing me away. 100 years later, the family is still connected to that wealth, still has influence, still benefiting from what he built. Why? Because they had structure, they planned, and had control, have control. So, what's the difference between all three? It's not money, it's not intelligence, it's not opportunity, it's structure. And that's why you probably heard this before. The first generation builds it, the second generation enjoys it, the third generation loses it. Or you might have heard this: shirt sleeves to shirt sleeves in 3 generations. Now, that is, to me, was just so profound to know that your family is still being taken care of 100 years. 100 years. Like, that's crazy. I'm like, wow, that's amazing to be able to, to do that. And one of the things, like, I like millionaire and billionaire success stories, and I like knowing these different things because it gives me a foundation. right? I like to know these things ahead of time. Like if I didn't learn about these stories and hear these success stories, I wouldn't have never did a holding company for my companies. I would have never done that. I would have never like know that the trust is next on my agenda list. So these showing up, I just want to give you all the applause because I see millionaires and billionaires on this call, okay? Millionaires and billionaires, and we need to know how to do this. We need to know our families, our children, our children's children, your nieces and your nephews, they are watching, right? And people are waiting on us to show up correctly. They're watching, and we have to change our trajectory, especially in our culture, you know, um, for generational wealth, how to handle their money. And so I'm excited about our guest today. Miss Tina D. I don't want to mess up her last name. Miss Tina D. She has been on here before, and every time she really brings it and she really shares the information that we need. And I love her personality. I love the education that she shares with me. I love how she keeps in contact with me to make sure I'm in line and I know what I need to do, my uh, next step. And a lot of us may be paying a mortgage, right? Some of you may be paying a mortgage. My house, thanks to God, my house is paid for. But when your house is paid for, do you know what's the next move that you're gonna make? Like, what's the next step? So I'm excited um, about this. And Tina, I'm gonna go ahead and let you take the floor.
Well, thank you, Lakeisha. Thank you for inviting me on, and it's nice to see everybody here. Um, Estate planning is a big realm of information, quite honestly. A lot of people think that estate planning is for the uber wealthy, but quite honestly, it's for everybody. It doesn't matter if you own a home. It doesn't matter if you have little to no cash. There are certain parts of estate planning that are still very important, and it doesn't surround your assets as much as it surrounds you. So I'm going to talk a little bit today about guardianship and conservatorship and what happens to people when they become incapacitated. There are two different types of probate. There is death probate, which deals with the obvious. You go into court, your family goes into court if you don't have the appropriate documents in place, and they probate your estate, which I'll explain a little bit about that later. But the other portion of estate planning is living probate, which a lot of people don't know about, and that is involving you personally. If you do not have the systems in place, then it could mean things for you down the road that you weren't expecting. So if you were to become incapacitated, either by a diagnosis of Alzheimer's or dementia, or if you have a stroke or a car accident and all of a sudden you can't communicate with people and you can't really tell them what your wishes are, it's good to have that done before something like that happens. And those situations are cured by durable powers of attorney. So a durable power of attorney is a lot different than a general power of attorney. A durable power of attorney is something that comes into effect when you become incapacitated. And what it does is you have already appointed somebody to become your guardian and your conservator. And a guardian is the person that makes decisions regarding you. Where are you going to live? What are you going to eat? What are you going to dress in? What are you going to, where are you going to live? Who are your medical professionals that are going to take care of you? If you don't have that in place, then the person that you thought you would have liked to have had will be designated by a judge. And that is always, that could be somebody that you don't even know. There's a lot been said about guardianship and conservative in the news lately about hired and paid guardians and conservators. And it's a little distressing when you start seeing stuff like that, because people like these can be self-serving, work in their own interest instead of yours. Likewise, just like a conservator. A conservator is the person who would have full access to your monies, your financials, and would act on your behalf and do everything that you would have done prior to you becoming incapacitated, like paying your bills, making sure that your household is secured, maintaining your property, and those things. So guardianship and conservatorship is an important part of an estate plan. It's also important too for people who have children. If you haven't outlined who your guardian is going to be for your children, then it's up for anyone to apply. And usually it's somebody in your family. This isn't a scare tactic, but it would help you rest easier at night when you know that you have already chosen those people to be your representatives. So what Legacy Assurance Plan does, we are a full service estate planning provider. And although I'm not an attorney, I'm a paralegal. We have a network of attorneys that are affiliated with us in the 26 states that we do business currently. And they are the attorneys are the people who will put your wishes into place by preparing your document packet. So Legacy focuses on a complete estate plan, which includes a will, which is a pour-over will. It includes a trust. It includes durable powers of attorney for both financial and medical. And it involves an advanced healthcare directive that goes hand in hand with a durable power of attorney, because you can choose things like how you want your body treated after you have passed on, things that you want to have happen should you need life-sustaining measures. You can choose all of this prior to any of that happening to you. So Legacy puts an entire plan together to completely protect you so that when it comes time that you have to leave us, everything will be in place. The big thing that people like to avoid is probate, and I touched on that with death probate. So what happens with death probate is every single will in the United States needs to be probated. It's a law. There's nothing we can do to avoid that except put a revocable or an irrevocable trust in place. A trust is very similar to a will in that it's created to hold your assets, your titled assets, your home, your any land that you own, motorhomes, anything, vehicles, anything that has a title, that is created to hold that. And when it's in the trust and completely properly prepared and funded, and the funding process is putting everything into it, then it completely protects your family from probate. So why is probate such a big deal? A lot of people don't even know what happens through probate. When you go into probate, if you don't have a will, or if you do have a will, you still have to file for a hearing to open a probate estate for you. That costs money. It can be, according to the courts, it can cost anywhere between 3 and 8%, the whole process, 3 to 8% of the total value of your estate. So it's not hard to get to $1 million in terms of an estate, especially if you own property. You have a 401k, savings, any of that. So just use the numbers to calculate it. I like to use $1 million because my math isn't that great, so it's easy for me to rattle off the number. But if your estate's worth $1 million, you conceivably could pay anywhere between 8 and anywhere between 6 and 8-10% of the value of your estate. So that could be anywhere from, let's say, $60,000 to $80,000. It could be as little as 3%, which is $30,000. That's a lot of money to people, and it's a lot of money that shouldn't have to go to the government. It should go to the family that is inheriting it. So cost is the big thing. The other thing is the publicity surrounding probate. When you pass away, a probate proceeding is totally public. It will list the date of death, your date of birth, all of your assets, the value of your assets, all of your debts, who you owe your debts to and how much. It also shows who your heirs are and what they're expected to receive. And anybody can go into court and see this. And a lot of people do. A lot of people go in to see, oh, somebody inheriting a house that I can approach them before it goes on the market and get the listing. There are nefarious creditors who can go in, contractors, and say, well, they didn't have a will. It's an intestate probate, meaning they didn't have a will, so the government is choosing their way that things are going to be inherited. and they can file false claims, and it would be up to the estate to prove that that is a false claim. So the whole thing about the privacy is very important because nobody should see what you owned and what you owed and who's going to inherit what. The other big challenge with probate is the time involved. The courts say that on average it takes 6 to 18 months to probate an estate. And that is because, courts, when you go in to do the probate, attorneys need to be hired. Then filings need to be made. The properties need to be appraised, assessed, and valued. Reports need to go back to the court. It's just very time consuming because these processes don't happen overnight. It can take months for the next step to happen, and it does happen. So on average, I would say it's about 18 months. You may have seen a lot of the public probates on TV, like the Prince and Michael Jackson and Aretha Franklin and Sonny Bono. None of these individuals had estate plans in place. And in fact, I think Michael Jackson's estate may have taken over 10 years to probate. It might still even be parts of it in probate. So, and all the time that it's in probate, your family has no access to the funds. So that is why probate, people want to avoid probate because it's just very, very onerous on the family, time consuming, stressful, and can cause a lot of strife within your family by them seeing everything that is going on publicly. So that is one of the things that a trust can avoid. A trust, like I said, completely avoids all of these steps of probate because you pass away and the very next day, your estate can be distributed. I had a neighbor who passed away. She was diagnosed with terminal cancer. She had a trust in place and she had already undertaken the powers of attorney. So she knew exactly what was going to happen to her, who was going to take care of her, and who was going to make the decisions. So she came over to talk to me and said, I just want you to know that this is what's going on, which was very upsetting to me. Obviously, we'd been in touch with each other for over 20 years, but she didn't want me to be upset because the first thing that was going to happen after she passed away was a real estate sign was going to go up on the property. Like very next day is what she wanted to have happen. She passed away in June. I live in a coastal community in York, Maine, and it's very desirable. A lot of people from Boston come up and they like to buy properties and they have a lot of cash. So sure enough, she passed away. Her sign went up by the real estate broker. Within 3 days after the sign, I mean, she barely was put to rest. The sign said under contract. And then within another week, the sign was removed. Well, what happened was a family from Winchester, Massachusetts, very wealthy community, came up. It was June. They loved the house. They put it under contract with no contingencies, cash closing. They wanted to close within 2 weeks because they wanted to use the home. Summer was coming. We have access to the river at the end of our property. So within 2 weeks after Margaret passed away, her sons, 3 of the sons were each handed a check for $325,000, the proceeds after expenses for the sale of the house. They didn't have to go into court. They didn't have to ask the judge permission. They didn't need to prove that they were the lawful heirs, and they had the cash immediately. So that is one of the success stories behind a trust, and that is generally what happens. It all gets dispersed the very next day. The Legacy Assurance Plan is there to help the individuals because it is a membership. We're there from day one when we create your plan. It starts with me meeting with you and helping you decide what is necessary for your estate protection, asset protection, and what you want to have distributed. After that, we schedule the attorney appointment. You get in touch, you have your attorney appointment. It's generally within 2 weeks of your membership. The attorney will then proceed to prepare your plan, and it's state specific because they have to be licensed in the state that we are doing the plan in. They have to spend 70% of their daily activities doing estate planning, and you can rest assured that Legacy Assurance has already vetted them. We pay them because we have negotiated their rate because we send them a fair amount of business. So once your plan is created, once he talks with you, he then creates your plan, which includes the package of 6 documents. Again, the trust, a pour-over will, 2 powers of attorney, and advanced medical incentive. We also help you with the funding process. If you own a house, we pull your deed and we retitle it to be you instead of individually. You're titled as you as the trustee. That's the only way the funding process can happen because you physically can't take a home and stick it in a piece of paper. You have to transfer it somehow. And that's how you transfer it. So if somebody goes into the registry and they see that you own this property as a trustee, they're like, they've got a trust. That's good. So now we know, how this is going to happen. Real estate transactions happen every day through a trust. You can easily sell your property out of your irrevocable trust. Likewise, you can buy it back into your trust just by using your name as the trustee, and you name your trust. So those are some of the things that can happen working with legacy. We're there if you're a married couple. We're there when the first person passes away to help restructure the estate plan again. It's all part of your membership. You pay one bill up front. You never get another bill going forward. We're also there at the very end when there's nobody left except your heirs. We help them close out the estate. We help them with any required affidavits that are needed. So basically the takeaway from this is that legacy doesn't just hand you documents. They are there to provide services for life, and that's part of your membership. So that's one of the good things about it. But estate planning is crucial for several reasons, not only for asset distribution, but also a well-structured estate plan can minimize your tax obligations, your estate's tax obligations. They're currently the federal inheritance tax threshold for on the government level, federal level, is about $15 million. So your estate, if it's under $15 million, is basically tax free when your heirs inherit it. However, there are 6 states in the United States that have an estate tax that for states, and that means that, and they're state specific for each state, how much their threshold is. Massachusetts is $2 million. So any amount over your $2 million estate, although you don't pay a government federal tax, you do pay an estate tax, and it can be anywhere between 8 to 16% of the balance of your estate over the $2 million. So there are a lot of things to take into consideration when you're talking about an estate plan that you may not know, but working with a qualified estate planner does know. Also, like I went over when we first started, was the avoidance of probate and the healthcare decisions surrounding guardianship independence. So basically, working with legacy provides total peace of mind. You can, when you prepared your plan and it's all executed and notarized, which we do, we come to your home with your plan and notarize it. It's part of your service. Then you can go to bed at night with the peace of mind knowing that you have a plan in place that not only protects you, but it protects your family as well. So that's it. It's in a nutshell. I was very brief and tried to just kind of give you an overall, but I am very happy to schedule an appointment with any one of you to discuss it in further details, because each one of you, your circumstances are different, and it needs to be looked at from that lens that your assets are not the same as Lakeisha's. Likewise, Lakeisha's assets are different than yours. We also can help people fund their LLCs, holding companies, corporations into the trust. So we make sure when we get done talking with you that we know everything about you, and we make sure that everything is covered so there are no surprises. There are no unknowns. So that's it. If you have questions, I'm happy to try and answer them. I've also put my contact in the chat again. I believe it shows up now. So if you want additional information, I can answer questions on almost anything. If I don't have the answer, we have written materials that I can go over, and I can forward a brochure to you. So questions?
Yes, I have a question.
Okay.
All right, so recently I was talking to a couple of my clients, right? And then they only have one child. And it was amazing that they both were under the assumption that just because that they only had one child, that everything automatically went to them easily and effortlessly. And that is not always the case. Because I want you to talk more about it, but what I do know, and you can correct me if I'm wrong, like if let's just say, if your house does not have your child's name on it, it doesn't go to them easily and effortlessly. If you have a bank account and only your name is on it, and it's not maybe like paid upon death, then they won't be able to get that easily and effortlessly. What is your your advice on that? Is that correct information or is that incorrect information?
Well, it is, and it is in a roundabout way. So what we recommend is, like I said, in the trust, all the titled assets go into it. But if you have 401ks, IRAs, annuities, CDs, you have a checking account, a savings account, you want to make sure that you've talked to your financial people, and you want to make sure that there are payable on death benefits, because payable on death benefits or transfer on death benefits do not are paid outside of the estate. They're not subject to probate. So that is one of the big things that you can do, unless a person decides to make the trust the beneficiary. If they have so many years that they want to make sure everybody gets an equal proportion, you can name your trust as the beneficiary upon your death. It makes it, in terms of a 401k, that could be a little sticky, because sometimes the when you transfer the name into another name while you're still alive, it could trigger a tax implication. So you'd really want to check that out with a financial advisor. But in terms of your home, you're right. If you don't have you're both, say the husband and wife dies and the child isn't named as the sole beneficiary, then it would have to go through probate, and it would be distributed, and it would still be distributed in accordance with the will. But the other thing is talking about people who don't have a will, and I'm going to stress this because 70% of all Americans in the United States do not have any form of estate planning in place, zero. So they figure, well, if I die, everything's going to go to my husband, and my husband is going to, distribute it to the kids, and when he dies, the kids will automatically get it, like Lakeisha said. That's not the case, because if you don't have a will in place, there are things called the laws of succession for intestate people. That means every single state has a plan waiting for you if you do not create your own plan. So, for instance, I can't tell you what the succession laws are in every single state, but I can tell you I live in Maine. So it was eye-opening to know that if I were to pass away without a will, I would have assumed, maybe if I didn't know about the education that I received, that my husband would inherit it. That's not the case. In the state of Maine, if you don't have a will in place and you have a husband and you have children, there is a succession that happens. Your husband gets 50% of it, and then your husband will get 15% of the remaining 50, but that other 35% gets distributed to your children, and then it goes down. If you have no children, it'll go down to grandchildren or nieces or parents, siblings. There's a structure of it, so it doesn't happen like the way that you think it will. Also, same thing with, just to expand a little bit, if you don't have powers of attorney in place and you say, oh, if I pass away, my husband's going to make the decisions, of course we're married. It's not always the case, because you still have to go into court. You have to open a living probate. And if, let's just say the husband's been diagnosed with early onset dementia, or after speaking or interviewing the husband, the judge doesn't feel he's qualified to make those decisions for you, he has the legal right to appoint a paid conservator and paid guardian. And like I said, somebody may be changing your clothes, bathing you, and you might not even know who they are. So that is, I think, did that answer your question, Lakeisha?
Oh, absolutely.
Okay.
If anyone doesn't have a question, I'm not paying attention to the chat.
Yeah, here's a question that says, if children are listed as beneficiaries, do they still need to do a trust? I don't know if you already answered that.
Well, you do, even if you say, like, you're assuming they have a will, is that what you're assuming?
I'm reading this.
Okay. Well, if your children are listed as beneficiaries, it depends on how they're listed. If they are payable, if they're financial accounts, then those won't go through probate. They'll transfer automatically to your heirs, and that's what we suggest. The main asset that people have is a house or titled property, land, a home, motorhomes, boats, expensive vehicles, that type of thing. those things will not automatically go to your children. If you have a will, it's still that based on the amount of the will, you still have to go through probate, and then it will be decided. The judge will take in consideration what is written in the will, and generally speaking, that does happen. But to make sure that you're totally protected, a trust is the only thing that doesn't go through probate, and it's the only thing that you don't have to get permission to distribute your estate. Does that answer your question?
Yes, it does, if you can hear me.
Yes. Okay.
Yep.
I
Thank
mean,
you. I was a friend of mine, father just passed away in May, and they're here in Michigan and they have property in Alabama, and they had it, their parents had it set up really well. I'm assuming now that it may have been a trust because they didn't have to deal with probate. So I was just telling Lakeisha the other day, their father has about 280 grand in a bank down in Alabama. So they actually had to get an attorney to get that because the bank was not a big bank. It's a small Alabama bank. And the only person that was on the account was the wife, and she had already passed away.
okay.
So yeah, so
Yeah,
that's why I was asking.
that's why it's important to make sure. A lot of people, when I go into their homes, they'll say, I'll ask them if they have beneficiaries and they have a fair amount of money. And they're like, well, yeah, I think so. I must have done that when I opened the account. Not always true. So that is something that we make sure that you do check and you do. And the other thing they touched upon, having properties in two different states, if they're not properly funded into a trust, could require two probates. One probate in Michigan, another probate in Alabama. So it's double the cost. And that's another big thing. And your children, if they're the ones that are left to be the beneficiaries, they may be required to appear in court in both places. That, expenses traveling to Alabama. Maybe they live in Florida, so they have to deal with the probate in Michigan. They'll also be required to maybe file a bond and some affidavits. So there's a lot. It's easy to give you general information, but it's when I meet with people, I give specific information because I know what their situation is. Okay, does that make sense?
It does. So even having a trust, um, again, I'm assuming they have a trust. In a couple weeks, I guess the bank's going to release the money to them,
Yeah.
but they have to be there in person. So they won't do it wire. They have to
Right.
physically come down and bring
Right.
ID.
So they
So
could have
yeah,
had a trust. They absolutely could have had it. It sounds like they may have because they didn't have to go into court to probate any property. But
right,
that's the exact reason why we make sure when we sit down with you, if you do have an account in another state or you have an account in the state you live in, if there isn't a beneficiary on it, then yes, there is going to have to be a legal proceeding of some sort. Maybe not, and it could have been a simple probate just for that one account, but an attorney needed to be hired and paid, right?
right.
So,
Yes,
and it was something that had there been a transfer on death or payable on death, it would have just been paid directly to whoever that person was listed on the documents.
right.
My
Yes, they attempted to get their dad down there before he passed away, but he was 91 and stubborn, and he was like, I don't want to do it. So yeah.
yeah, so I mean, it's important to make sure that everything is protected. I did a plan for a lady in Massachusetts, a lady and her husband. They had $14 million in properties, $14 million in properties. And none of, they paid a local attorney, I don't know, somewhere around $8,000 to prepare just the trust alone. They didn't even get durable powers of attorney. And she started looking at the trust and called me and said, I don't understand. Where do I see my properties in here? I don't understand how it works. Is it just, I have a trust, so it automatically is there? No, it doesn't automatically go in because I checked the registry of deeds before I went on the appointment. So I had to tell her, no, nothing is in the trust right now. You paid $8,000 for a piece of paper that is worthless. It's not worth the paper it was written on because nothing is in it. It's not funded. So that's the important thing. Having a trust is great, yes, but more important is it needs to be funded, right?
Okay.
So whether the property is in Alabama or whether the property is in Michigan. So what probably happened if your parents had a trust is they changed the deed in Alabama, to read Mr. and Mrs. So-and-so, trustees of the Mr. So-and-so's revocable trust, or whatever trust it was. So that automatically funded it. So the trust, the house most likely would have transferred properly and quickly to the heirs.
Yes. It did. The house, it was no, and
Okay.
we were having this conversation, and it did. It transferred quickly. So I'm going to assume that he has a trust. I haven't
Right.
asked him,
Yeah,
but
that would make sense. Absolutely. But
okay.
they forgot about the money. They forgot about the account.
Right. So had they included the bank in there, that would have been okay, right? In the
Well, they
trust.
wouldn't include the bank in the trust. Financial documents to make sure moneyed accounts need to be payable on death or transferred on death. And that transfer on death
Okay.
can be made payable to you personally, or it could have been made payable to the trust. Therefore, when the last person passed away, that money would have been forwarded to the trustee and put into the trust immediately. It should have happened immediately.
Right. Okay.
There's a
Another
oh,
question,
go ahead.
and this one's different from, owning property or anything. So say, for instance, you have IRAs. Say you got 3 or 4 IRAs and they've been building and growing and you have a beneficiary there. You put the IRAs in the trust too?
You don't have to. If you have a specific beneficiary that you want, and you need to make sure that you don't inadvertently disinherit a child. Let's just say you have 3 children, and you
Hmm.
decide to put your eldest child on all of the accounts, all the financial accounts, and he's instructed by you, not written anywhere, but he's instructed that he's to distribute amongst his other 2 siblings. That doesn't
Hmm.
always happen. In fact, 9 out of 10 times it doesn't happen. And that's, children don't speak to one another. They don't even like each other. And so I've seen this happen time and time again. They take the money and the other 2 siblings have been disinherited without, and
Hmm.
that wasn't the intent of the parent. So what we suggest is, because financial accounts it's a little more problematic to transfer them into the trust because it could be tax implications. Okay, they could
Hmm.
be, like a 401k. I know that you can't transfer it into the trust when you're alive, because then the ownership is going to change. And then all of a sudden you have a $400,000 401k, you're going to be paying the capital
The
gains tax.
taxes. Right.
So there are a lot of different factors involved, and that's why it is so particular to each individual. And
Okay.
somebody may say, well, that's what I have to do, but they forget to tell me that they own land up in Machias, Maine, 200-acre tree farm. And they're just kind of back in the back of their mind, and it really doesn't have much of a value, but it's there. Well, guess what? If that's not listed in the trust, you're going through
Mhm.
probate. So and
Right.
that's the thing about legacy. We make sure that you are completely protected. We also provide a yearly check-in. We would call you and say, how's it going? Did you sell your house this year? Oh yeah, I did. Okay, did you buy another house? Yes. And what is the house titled in? Oh, it's in mine and my husband's name. Well, wrong. That's the wrong answer, because you sell a house out of your trust. You let the broker know you have a trust. So when the closing happens, your deed is going to say, your title is going to say, Tina DiPietrantonio, trustee of the DiPietrantonio Trust. Boom, goes right into the trust without them even thinking about it. So,
Mhm.
and those are things that people in the first couple of years or the first few transactions, they might get a little confused. They have the ability to call us and we'll walk them through this step. Whereas with an attorney, and I'm not trying to diss attorneys, but generally speaking, they get paid when you go to visit them. They get paid per document or whatever the fee is charged, and they hand them to you, and that's it. You're on your own. You're on your own to figure out the funding process. Generally speaking, at least this is what I have found. Maybe some attorneys are a little more proactive in that area, but generally speaking, because I see more trusts that aren't funded. It's really sad. In fact, the owner of our company, Legacy Assurance Plan, the reason it came into existence was in 2006. The owner of the company, they own several large insurance and financial companies. It's a big deal. There's 150
Mhm.
employees in their building in Florida. Well, the patriarch was ill, and the sons went to him and said, hey, Dad, do you have everything in order? Oh, yes, I have a trust. going to be easy as pie when I pass away. Everything, you're not going to have to do anything. It just will come to you. Well, guess what? He died. He had a trust. Absolutely. Paid $11,000 to have the trust and all the documents drawn up. There was nothing in the trust. So the family went through a very long and onerous process of probate, cost them lots and lots of money. So when the process was done, the two sons, who, by the way, were attorneys, not estate planning attorneys, but they were attorneys, said, this is ridiculous. You know, we're smart people. Our father was a smart man. There's got to be other people that have found themselves in this situation. And they were absolutely right, because the American Bar Association has come out with a study and said every single attorney in the United States can legally prepare an estate plan. But these aren't my words. This is from the American Bar Association. Less than 1% are truly qualified to do an estate plan correctly. So after they got done, they said, you know, we should be able to come up with something that all their clients, all their financial clients and insurance clients, there were hundreds and hundreds of them that didn't have it, thousands of them that didn't have estate plans in place. So they started this program, Legacy Assurance Plan, which basically was provided as a service to their existing clients. And it became so popular that they started growing and offering it to the public. It never changed their price. Their price is extremely reasonable. It's based on each individual's it's basically the same price for everybody, but then there are some things that move. If you have more than one property, there's an extra deed charge like that. So, and we pay for the attorney fee. So in that price, for instance, and I'll shoot some numbers at you. They may not be your numbers because you may have additional things, but for a basic person with a house and some financial accounts, couple of children, for a single person, it's $2,895, $2,895. That includes the attorney fee, all of those documents, and the services for life. If it's a married couple, because we have to do a double set of documents in terms of the powers of attorney, advanced healthcare directive, it jumps to $3,295. But we also run promotions from time to time, taking $200 off if you provide me with some names of friends that might be interested. They don't have to commit, but somebody I can call on and explain it to them. Then we'll take $200 off. Legacy also has a plan that it's sort of a benefit for people. So if you become a member and you like the plan so much and the services you're getting, and you start referring people, we will actually send you a prepaid Visa card for every referral you send that becomes a member. And it starts at $125, then the second goes to $150, the third goes to $175, and the fourth, and every referral after goes to $200. I have an 84-year-old lady in Gray, Maine, who has a stack of those cards by now. She's probably paid for her plan because she was a member of a garden club. She golfs, and she was just out there to my services, and yeah, she was incredible. So that is sort of a benefit. You can actually make back money to put towards your estate plan, and in the end, you can almost pay for it, quite honestly. So
there was a young lady, Queen B. Yes, she had a question.
Okay.
Thank you, Tina.
You're welcome.
Good morning, everyone.
Good
So
morning.
I like that part that she was just saying, because I'm going to have meetings where I'm actually going to be talking with Lakeisha and a whole group of ladies about advanced care planning and getting their house in order. But I'm going to just kind of check my dots and T crossing the C. So I have my daughters on my bank account as my beneficiary. Is that okay? And also, when it's time for me to leave here, I have like a legal forms already for affidavits for them to go down to the courthouse, I guess, and give it to them to get it switched in their name. Is that okay? Or should I just take all of this stuff that I have and put this stuff in the trust?
So your financial accounts, again, like your checking account and your savings account, annuities, CDs, you put it in the name of the beneficiary, it will go directly to them. So if you have two children, you might want to put them both on to get 50% each.
Okay, I have four, so should I do all of them?
All four, put all four,
Okay.
each get 25%. But you don't want to, you shouldn't have to have you shouldn't have to go into court and get any permission. The financial institution should just automatically do that.
Okay. No, I didn't know. And then I was just saying the other part was for my home. I have affidavit papers already completed, and it's in my my fireproof safe for them to be able to get and take down to the courts to just get the home in their name.
No,
No?
that won't happen. You can't just do something like that. It has to go through a process. So if you're an affidavit saying, please transfer this, it doesn't cover all
Attorney brought
legalities.
it
And
up.
again, I'm not an attorney, but I do know
Attorney
somebody
did
had that
this.
similar situation.
Mhm.
It needs to be specifically noted in the either the will, if you're not going to do a trust, and a will is still going to go through probate. But if you put your house into the trust and then name your 4 children as 25% beneficiaries of the trust, they will get their 25%. Does that
Okay,
make sense?
this one I'll do a trust. But the other part is, what about if I own businesses like nonprofits and LLCs? Should that go in the trust or how does
Yes,
that go?
yes, you can, because you're the sole owner of the trust, the LLC.
Yes.
Yes, we have a funding process. We will help you fund the LLC into your trust. There's an upcharge on that. I think it's around, it might be $350. And what we do is provided you have articles of organization and all of that stuff is in place, your LLC is properly set up, then we just we name the trust as the beneficiary and it goes automatically in. If you don't have a beneficiary and it's not put into a trust like that, your LLC, depending on what the value of the assets are, could possibly go through probate.
Okay. Okay.
Okay, I
Thank you
have a
so much.
question. Go ahead.
Does
So
that answer your question, Queen Bee?
Yes, ma'am. Thank you so much. But I'm
Welcome.
going to be doing some events, so I might call on you. I did get your information from out the chat,
Absolutely.
and
Absolutely. Call me anytime.
might be sending those folks to you too once we have the meeting when I work for
Okay.
Lakeisha moving forward. Thank you.
That
Thank
sounds
you,
good.
Lakeisha.
Thank you.
Mhm.
yes, absolutely. Okay, this is a common question. Can a guardian control my child's inheritance, or is that separate?
So basically, if your child is underage, not of majority, they're minors, then several things can happen. You can do whatever you would like, but you can set up in your trust that should that child, you pass away and that child is still a minor, then you can appoint somebody to oversee their inheritance and have access to it. You want to make sure that it's somebody that you trust and it's somebody that is going to follow those wishes. The other thing that we didn't speak about, and this happens a lot, is a child with a disability or an heir who has a disability. So there are special documents that are going to need to be put in place. You can't just list your child or heir with a disability as a beneficiary because they're already ensconced into the plan with disability. They get health insurance, they get monthly support, they get a lot of benefits. And should they inherit $100,000 all at once and it's not protected, the government's going to make them spend. They're going to be, first of all, not going to have access to any of those benefits. They have to spend that $100,000 down, and then they can reapply to be qualified to get care from the state. And that is something that people don't think about. But what we do is when there is a child with a disability or an heir, within your basic trust, we put a provision that upon your death, a supplemental disability trust is going to be created for that child immediately upon your death. And anything that that child or heir inherits is going to go into the supplemental benefit trust. And the reason for this is the trust is going to be created with specific language that allows them to draw from that trust for things that are going to benefit them: education, maybe a vehicle, a home. They can use those monies for that. They can't just take the money out and go out and have a big party. It's designed to enhance their lives, and it won't affect their disability if it's done right. Does that make sense?
Yes, that was so good. So good. So, what's a good process to making sure you choose the right person for your trust to be, over your trust? Like, what are some things that we should really look at? Not just because they're your family member, like best process should you look at before you actually make that decision who will be over your trust? Is
Well,
there a
there are
best
several ways.
practice?
Yeah, there are several ways you can approach that. Most people, to be honest with you, within their will, they're within their trust, they're reciprocal, right? The husband dies, the wife gets everything. The wife passes away, then it gets distributed to probably their children, if that's who they had. Let's say they had 3 children. Then the successor trustee, generally one of those children, or all 3 of them, can act as successor trustees to close out the trust. If all 3 of them are heirs, they can be. But generally speaking, I've seen people choose their eldest son. That doesn't mean that he has to follow the succession in the trust. He has to distribute the monies according to the trust. So it's not like a payable on death, a transfer on death, where that son, once he gets that money, you're gone. He doesn't have to do anything with it but keep it, right? But within a trust, so that's generally what happens. It's the husband is the wife, and the wife is the husband's successor. And then in the end, it's usually, and a lot of people, if they don't trust their children, there are banks that have professional trustees that you can go in and ask them to be the trustee of your estate. It costs money. I mean, there is definitely a cost to that. I've not had that. I've not had to have that situation. Most people, if it's not one of their responsible children, then they choose a sibling, a sister or a brother, because even if they're not inheriting, they still are the one overseeing the trust and making sure that the trust is followed according to your wishes.
Someone had a question. They said, you said 2,800 for life, meaning a one-time payment, no monthly
So,
fee?
right, it's $28.95 if you're a single person. So what happens is you pay that, and that's provided you have, just one deed that we have to transfer. You don't have an LLC or anything like that. That's the payment that you make up front. And right now we're running a promotion that's $200 off, right? If you provide 2 referrals. So what that gets you is a full consultation with me. Then it gets you a paid appointment with the attorney who's going to go over the membership agreement we've already filled out. He's going to ask you questions and make sure that he's got everything covered. Prior to that meeting, we provide you with some information to trigger your mind to ask questions that you may not have asked the member consultant like me. So the attorney will have all the information. Once that is done, then the attorney will prepare the documents. That's usually within 6 weeks. So it's generally an 8-week process from start to finish. And everything is included in that, including the ongoing services beyond, providing, answering any questions free of charge, being there to assist your heirs, your spouse, whatever. The other thing, so that's what your payment gets you. It gets you the free notarization in your home. It gets you an access to a fiduciary level financial person if you want, that can even talk to you about other things like death benefits and planning for long-term care. So that is part of the services. Now, should you need your documents replaced, we have what we call an assured care program. We pay for that the first year that you're enrolled as a member. It's $100 a year. And after the first anniversary, we will call you and say, how's everything going? Do you want to still carry? It's like a warranty like you would buy on your refrigerator, only it's less than a cup of coffee a day. Actually, for me, it's probably less than a cup of coffee a day per month if you go to Starbucks. So in any event, if you carry that assured care program for $100 a year, you can change out any of your documents, 3 of them free of charge, the other 3 at $35 a piece, period. That's it. So you'll never have to pay the $28.95 again. It will. And then a lot of people will choose to continue with that warranty, especially younger people, because they don't know if they're going to have more children. They don't know if they're going to stay married. Who knows what's going to happen, right? And if they have to change out their documents, that's a whole new appointment. And it could be just like when you call your attorney, your private attorney, every single question you ask and every new document change is going to be a fee. It won't be at Legacy. In the first year, it's completely free. After that, if you carry the $100 a year, it's a benefit to assure that you're not going to have to pay the $28.95 again, or the $32.95 if you're a married couple. So does that make sense? Do you understand that?
Yeah. Someone asked a question, I believe it was Miss Bridget. Do you do in-person visit? How is the visit? How do you conduct that procedure?
Well, it depends. I handle the states of Maine, Massachusetts, and New Hampshire in home. I do Zoom this way. I can't even tell you how many plans a month through Zoom because it's just as personal. We still, your attorney appointment is in the state that you live in. But if you really needed an in-home appointment, it wouldn't be me. I could refer you over to a different representative, but I find that even the Zoom calls are pretty effective because we can schedule as many of them as you want. But I'm not going to drive to Michigan, for instance. So
Right.
it's going to be
Well, no, I'm asking in the sense because my boyfriend is one of those, I got to see it. I want to talk to the person. I want to be in person with the person. So that's why I was asking. And
well,
he would,
yeah, I understand that. They are going to see the attorney as well. I mean, you can have an
yeah,
in-person appointment with the attorney. They charge a little bit more just because they are charging such a reduced fee that it's just easier for them to jump on a Zoom call. An attorney can do
yeah.
how many Zoom calls in
Well,
a day.
and then I'm talking in the sense too of people not being tech savvy. So some people don't use Zoom, never use Zoom. So yeah.
I've
Okay.
had to walk 84-year-olds through a Zoom process. It's pretty simple. So we make sure that
Yeah.
you're all up and running. I had consultations by phone, to be honest with you.
Okay.
So you could do that. But if it was absolutely, you just, you need to have a person there, you would refer it to another rep. It wouldn't be me. It wouldn't be my advising you. It would be a different person.
Okay. Thank you. I appreciate that.
You're welcome.
I think we had time for a couple more questions. Anybody else have any questions? Is there any takeaways? I would like to know, by being on here, she's coming on here, were there any takeaways? Because there was a takeaway for me. Because I remember the first time we met, like I had a trust, which I thought I had a trust that was prepared. I paid for it. And you was like, what's in it? And so it wasn't funded. So you're the first person when I looked at that trust, I think I thought I really had something going on. And you said, no, what's in it? Is your house in it? Is this in it? Is that, So I thought that was very profound because you mentioned that several times today about people who pay this money for trust. They don't know. Like they thinking they got something. They
Exactly.
don't know and didn't know whoever prepared it didn't tell them that you have to fund it. Now that was a big takeaway for me from the very first time that you came to Grand Rising Elizabeth Wealth Building Wednesday show. Is there any takeaways? Anyone else have a takeaway?
Yes, I have a nonprofit, and when you said include your nonprofit in there, that was a good takeaway for me. Also, I think a good takeaway is, I think trusts are the way to go, especially if you don't want to get caught up in probate court. But I will definitely be reaching out to you, Tina, for sure.
I'd be happy to talk with you. And again, if any of you needed some more information, particularly on a revocable trust or the funding process, our company probably has 300 different brochures that are really done quite nicely. A 10-year-old can read it and understand it, I guess. They've made it easy for everybody. And I'm not trying to insult anybody, but it can be overwhelming when you're trying to get information. And I mean, I went into a person's home and they had stacks of stuff. Well, I got this from online. I went to another estate planning and I got this pile, and and then you ask them what they learn, and they're like, absolutely nothing. I don't understand any of it, So we pride ourselves on the fact that we make sure that you understand it, and we make sure you're completely protected when we do your plan. So that's
There are
a
two people, Doc Reed and Dr. Hoover. Doc Reed had his hand up first, and then after that, Dr. Hoover. Go ahead.
okay.
Yeah, Tina, thank you for the information. I've actually come across a lot of people, and I communicate the same thing, is it funded? And candidly, that's kind of where I am because I was promised, I redid my trust, so I've done it twice. And then, hey, we'll be in communication, we'll have that. And I know that there are fees and things associated with making changes whenever you sell a property or just life happens. So, my question though is, Do you refer to, for example, I offer financial plans for people. I don't charge them for that, but I do a lot of education, work with large groups of people. Do you have a network or a referral relationship for the rep who would be working? Because we work in all 50 states. I was wondering how that works.
Yeah, I mean, we have financial people within the company, but lots of times if I formed a relationship with an individual, I feel more comfortable sending them to the person. I belong to a BNI networking group here in Maine.
Mm-hmm.
And so for anybody in Maine, she only works Maine, we refer clients to each other. So that it is a possibility. I'd be happy to talk to you more about it and learn what you do. And, yeah, there could be definitely a referral relationship that goes on. And you had said something, and I'm not quite
Mm-hmm.
sure if I understood it right. You said, if you have changes to your trust, or selling property, I know that there's going to be a fee to change the documents. Who are you referring to? The fee that changed?
My traditional estate attorney, the one that did my estate plan the second time. If you
Right.
want to, yeah,
That's why we do the membership, because
yep,
you wouldn't have been charged to
right.
do your trust the second time. That's
Mm-hmm.
the thing. That's the beauty of it. You become a member and you get all that professional advice free.
Mm-hmm.
So, and guidance. It's the guidance, I think, that people are really appreciative of. And I delivered a plan. I'm also a notary closing agent that I do sometimes deliver the plans in Maine, Massachusetts, and New Hampshire. And I sit down with people and go over it and make sure they're fully funded and all this stuff. Well, I met with a
Mm-hmm.
couple November 11th, 2 years ago. I'll never forget that date because I live in Maine and the appointment was 2.5 hours away and it was snowing that day. And I said to myself, oh my gosh, I don't really want to drive, to north for 2.5 hours. And something kept nagging me. And I have really good intuition. So I said, nope, I'm just going to do it. I'm going to do the
Mm-hmm.
appointment. So I drove, took my time, sat with them, two elderly people, and made sure everything was done. I even took their deed that was put into the envelope and dropped it off at the post office, so it was going straight to the registry. They didn't even have to do that. 2 days later, I get a call from the wife. She was just hysterical. Her husband had passed away
Mm-hmm.
2 days after I delivered their plan.
Mm-hmm.
She said, I don't know what to do. And that's the beauty of it. You don't have to do anything. We're going to step in and help you.
Mm-hmm.
We walked her through the process. We prepared a whole new set of estate plan, whole new plan for her because obviously her husband, who was beneficiary, is now gone. So that is a classic example of what we'll do. And she did not get charged one extra penny.
Yeah, love that.
We
And
have
do y'all?
Dr. Hoover. Oh, I'm
I'm
sorry.
sorry. Do y'all have finance? Do you finance or expect payment like right up front?
So the way the payment is made, we did have a finance company that would do, it was sort of like a credit card. There was an upcharge, but we found people weren't using it. And then this company was going to charge more fees. And we said, no. So we don't have any financing options for you. What you do is you pay half the fee up front when you sign the membership agreement. And the other fee isn't, so that's 2,800 would be 1,445, right?
Mm-hmm.
The other half is paid at the time your documents are delivered, usually 2 months. It's usually a 6 to 8 week period that you can, try and put away some more money. A lot of people use a credit card and they get benefits, they get cash back, they get all these, mileage or whatever. So I find a lot of people use their credit card to do that. If they use it responsibly, it works for them. But
Thank you. Yeah.
unfortunately, right now, we're looking at trying to get another financing option in place, but we don't at the current time.
Okay. Look forward to talking with you later.
Great.
Dr. Hoover.
Yeah, actually, Doc Reed had asked one of the questions I was curious about, and that was a networking opportunity. The other thing is, I see you bringing huge value. That 1% of attorneys who are qualified to handle funds, that was a big statistic. That's huge. And that tells me there's a lot of people out there that's trying to be, jacks of all trades, even within the legal system, right?
Right. That's
They,
exactly right.
yeah, there need to be specialization, and your company is providing that. And I just want to, say that you're providing a huge benefit, and I just want to share that.
Thank you. That's absolutely what we do pride ourselves on because, you wouldn't, if you needed a knee replacement, you wouldn't go to your general doctor, right? You wouldn't go to your GP. You're going to go see a specialist. Same thing. I use that analogy. If you need an estate plan done, are you going to go to a bankruptcy attorney or are you going to go to a litigator? No, my daughter is an attorney in Boston. She does patent law. A lot of her clients are like Moderna and Pfizer. And I asked her if she knew anything about estate planning, and she was like, hell no. Why would I know anything about estate planning? I'm a patent attorney. So she stays in her lane. A lot of lawyers just need to make the money, so they don't stay in their lane. They're like, yeah, I can do your divorce. Yeah, I can do your bankruptcy. And you're right. And that's the reason why we vet our attorneys. They can't have a blemish on their license. They can't even have, nothing can be, they have to be totally vetted, and they have to know the laws of estate planning inside and out. And that's why we require them to spend at least 70% of their time doing that, because of that very reason.
That is so good.
Okay, hopefully I can ask the last question. So you have a trust, both parents die, and the beneficiaries, have the trust now. Do they have to pay a fee to keep the trust going for themselves, or is that a lifetime trust?
No, generally speaking, what happens after the trust, that the kids inherit the trust, and there's several heirs involved, they want to get their own money. At that time, we'll help them close out the trust. We can help them create a new trust in their name only for their family at a very reduced price like that. But yeah, no, because that trust is named for the people who created it, right? But
So
we're
it
there at the end
dissolves.
to,
It dissolves after they pass away, but at least legacy, you guys will help the
oh
beneficiaries
yeah, we
get into a
even
new trust.
provide them, if they don't have a financial advisor, maybe I'll refer it to the gentleman I was just speaking to, if it's, but yeah, they do, they go through and make sure that they have everything that is needed to do, to close out the estate. That's a nice thing about it.
Okay, thank you.
Awesome. It's 10:07. I do want to be respectful of everyone's time. And I just want to say thank you so much for everyone who showed up today. Thank you, Tina, again. Every time you come with a wealth of amazing information that's, that can change your life, your financial direction. And so I just want to say thank you. I've learned a lot. I'm sure everyone else has also. And so before we leave, I would love for everybody to give themselves a hug, because sometimes we're so busy and we're helping so many people that we forget to love on ourselves. So
Exactly.
please give yourself some love and some grace when you're going through things in life. Let's hug the world, because the world needs some love as well. And let's send love and light to all of those people that are in authority, because if we send enough love and light to those that are in authority, because the Bible does say, pray for those that are in authority, whether you like them or not. But if we send enough love and light to those in authority, you never know what kind of miracles could take place.
Absolutely.
So
Amen.
have a wonderful and fantastic day on purpose.
Thank you, Keisha. Love you.
Thank
Great
you.
job.
You too.
Thank
Love
you, Tina. We'll
you.
be reaching out to you for
Awesome.
sure.
Sounds good. I think you can grab my contact out of the chat, and I'm happy to answer any more questions. I know that it was a limited amount of time that we had, but I can answer more questions going forward.
Everyone be safe and have a great day. Love you all. Bye.
Thank you, Lakeisha, for inviting
Thank
me.
you, ladies. Live long and prosper.
Absolutely.
Bye-bye.
Yes. Bye.